This episode was sponsored by the Geopolitical Insight and Education Foundation. Want to find out more? Check the link in our show notes.
Welcome to another episode of Legal4Tech, the podcast. So guys, you do recognize my voice. It's always Rosie here. And as I've said many times, this is just for students and young professionals who are very interested in anything that has to do with technology. And yes, it's regulation. And today we're going to talk about, well, what happens if, let's say, the regulation of technology needs to be kind of used a bit more by the people that use the technology. So we're going to talk with a friend of the podcast and a personal friend of mine, Liz Coll, who's calling from the UK. Hi, Liz. Great to see you.
Hello. Thanks for having
I'm
me.
very happy to see you. Yeah. So, how do we know each other, Liz? I think it's quite important to tell our listeners before we dive deep into your career and why you're here today. So, we have actually talked on a similar episode of a webinar and a podcast that you were organizing with Euro consumers. That's correct, right?
Yeah, that's right. I work with Euroconsumers on the Start Talking webinar, which covers all sorts of different issues across tech and also just general consumer issues as well. So you joined us to talk about AI and women, which was around International
Right.
Women's Day, which was a really interesting conversation.
Oh, that was a good cause and a good chance for meeting and talking. And then obviously we then kept in touch. You also participated in a conference that we have talked about on the podcast because we've had a couple of members of the conference participating in the podcast as well. Paulina, Joe Pesh, I'm sure that our listeners will know who I'm talking about, and Misha Schimmel. So this is a kind of like the third person from that conference. But I'm super excited to talk to you because you're coming to tell us about your career, as we said, and also about something very cool that you're working on. And I'm sure our listeners will want to know more about. So let's dive deep. Firstly, starting from your career, why are you here, Liz? What brought you here?
Yeah, it's a good question. I don't think I've ever been a person who at a young age had set out a plan and had sort of fixed ideas, which I used to stress me out. But now I've realized actually that is kind of who I am. I follow what I'm really interested and passionate about, and I get excited by new things. And when I look back, I've been really lucky at taking that approach because I've ended up working sort of across and between and bridging between different parts of the work and the law and community and consumers in a way that really suits me. So, I mean, I would say to any kind of younger professionals, if you don't feel like you're on the same sort of very specific track as other people, that's probably because it's right for you. So don't worry too much about it. So I studied politics at university. And then I studied human rights and political sociology as a master's. I then began working for a sustainability NGO in education and helping universities adapt their strategies and become more sustainable across not just environmental, but across people and community and courses and the strategies. So I suppose that was quite a bit of organizational change and connecting with what people wanted. I then moved into working for consumer organizations, and I know that you'll probably know all about. You have your main consumer group in countries out there. In the UK, I worked for what was the National Consumer Council. So we were a statutory body with a watchdog role. And we're sort of commenting on policy, but also running our own research projects and thinking about what was coming up next. I worked in my first job there was looking at digital government, which at the time, let me just try and work out when I started there, probably about 2008. Pretty rudimentary, like the UK government website was called DirectGov. It was like a lot of links. It was eGov, but it was basically you can download a form. So there was nothing interactive. And we spent a lot of time looking at how that could be better. And then I think I started to make the link with the work I'd done before, which was all lots about civil rights and human rights. about this idea of, your rights as a citizen, and then your rights around your data, which the government could have, and how that might all be brought into new government services. And I just got really excited. I think what I really like doing is um, seeing how systems can work better. I often think in our lives we're sort of at the mercy of systems, whether that's standing in the line for an automated checkout, or whether that's not being able to see a GP, or whether that's policy consultations by government which don't really hear you. So I think I'm always quite interested in how systems can work better for people, should, and why that so rarely happens. So got very excited about the way that digital and technology could actually empower people. And I know that's an overused word and sometimes used in the wrong context, but that you could design technology around people for it to work for them. And the system that we've now sort of find ourselves in, we find ourselves in this status quo, but that's not the only way. It's just what we've ended up with, because that's been the dominant design and business model. But I think, and it's quite hard to think outside of that sometimes. It's just the way it is. Like, we give up our data, we use like 2 or 3 huge companies, but that is not the only way to do it. So I'm always quite excited about ways that you could, encourage change in that way and open things up. And obviously the law is one fantastic way of doing it. But I'm also very interested in how you engage people in it. And having done so much consumer research, what quickly brings you down to earth is people would like things to be better, but frankly, they've got a lot of other stuff on. So their job to sort of shift markets by switching and changing and demand is actually a bit more complicated than is always thought. So yeah, so that's the way that I work and the type of work I do. After working at the UK organisation, I then worked for Consumers International, which is a really brilliant organisation, the membership body for about 200 consumer groups all across the world. So you've got your VZBV in Germany, you've got your Which in the UK, Altro Consumer in Italy, Consumer Reports in America, and then you've got Australia, India, Zimbabwe, Mali. You have these groups all over the world, and it's a really interesting movement. So it's a global movement, and you will find people who have maybe possibly worked there since, consumer rights acts started to be part of constitutions or start of law like 50, 60 years ago. And it is a genuine movement which tries to work together to push things. I started working there to bring in a digital program. And again, that was in about 2016. That was the first time I spent a lot of time in Berlin, because I was brought in to work on the G20, which had the first ever consumer summit. So we put together some principles for what consumers in digital markets needed. And we did some research. We worked a lot with the German consumer ministry. And really, we were trying to bring together voices that were global. So what does access look like? What does control look like? What does fair treatment look like? But remember, at this time, the digital divide and the coverage in many of the global South countries was much, much lower than it is now. So, it was 10 years ago, but there's definitely been a massive shift with the rise of mobile phones and data, that it's actually incredibly vibrant now, and there's more connectivity. It's still uneven, obviously, particularly for women and particularly for people in rural areas and poorer people, but it's hugely grown. So the challenge was really to get principles for what good digital markets and world looks like for people across all these countries across the globe. So I started with that and then built out a program from that, looking at issues which people had in common from that. That's almost brought me up to date.
So I really liked the fact that you passed by kind of like a more international look, because we I think that the digital world is a very kind of borderless world, of course, but I think people see it as a very domestic issue because, after
Mm,
all, we bring our phones home literally, like, in our everyday activities. And I know people that, like, it's everything, single activity. So, like, really, it's very like, when you say your phone has become a part of your body, you don't see the digital world that it's a global world of expansion and of similarities. You
mm.
just see the thing that is in your hands, basically.
Yeah.
So yeah, I'm really like I'm really excited to see how kind of the international view that you had from your experience brought you to, being a consumer representative also in your country. So, like, the differences you saw in approaching this specific issues that I'm sure we will kind of talk about right now. So, as we said, there's a very interesting project that you're working on right now, and it's very relevant to our podcast and the conversations that go on. Um, Maybe you can tell us something about the case and what's happening, what stage you're on.
Yeah, sure. Yeah, so I think in 2020 I set up as an independent organization. Um, and that was partly due to, obviously, 2020 was do you remember the COVID pandemic? So that was a big shift, but I also was really keen to sort of get back into the heart of digital work. Um, and sort of timings are all aligned because in the UK we had previously had quite limited access to kind of collective or group claims. You could do it through one regime through the High Court, but that was quite an old-fashioned piece of law, and you needed to have like this very similar harm, and the group needed to have all be brought together and opt into the case. In 2015, the new Consumer Rights Act brought in collective proceedings, which were opt out. So it was in the Consumer Rights Act, but it was actually tied only to competition abuses. So it's slightly different, and we still don't have opt-out collective proceedings available for consumer law, but there is a consultation at the moment, so we shall see. Um, so that law came in 2015, but it was, as with new sort of regimes and new pieces of legal practice, it took lots of appeals, lots of process, lots of procedures before it sort of opened up and started in earnest. So there was a big case which was assessing really that you need to be certified for a collective proceedings. That was called Merrick's, which I don't know if people probably would have heard of, because that's been the most sort of landmark case that kind of basically lowered the bar for certification. And from then there followed lots and lots of claims. They're not all against digital, but I think I looked at it recently and it's probably about 50% are against tech companies. So they might be and they're basically accused of using their dominant position to cut out competitors, leads or other unfair practices, which might not be financially accessible at the moment, so around data use, um, and then bringing those to court. You're interesting. You're talking about the sort of global and international link. I mean, all of the big tech companies which are being bought. So there's Apple, Amazon, Google, Microsoft. They are all global companies, and I think that, just going back to what you said before about the sort of this very international connected digital world, which is also incredibly personal and at home and in our pockets. I think that really struck me the more work I did, that when consumers would say, well, that's not right, something needs to be done, you, we're not in the world where we can sort of nationally regulate that effectively, these big companies, or we weren't then anyway. So it's I do think that's quite interesting. I know it's not unique. I know that multinationals have always like been influential and had a huge impact on people's lives, but I think there is something a bit different about a company which is having such a, I don't know what the word is, I suppose, interpersonal relationship with you in terms of the data they have and in terms of the like connection, not just through the Wi-Fi, but the sort of emotional or like connection that you have with your phone. Um, so yeah, so being able to then bring these companies to bring to seek some justice against what the big companies are doing, not just to UK consumers, but across the world, is it was something that I really wanted to do. And knowing that there were also ongoing cases on a similar basis in Australia, Korea, and all sorts of different countries. So I should probably say what the case is about, right? So the case is against Google for exclusionary abuses of cutting out other competitors from the App Store market and in-app payments, and then overcharging an excessive and unfair price for apps and all subscriptions, in-app purchases. So it's the 30% charge, which obviously lots of developers had made quite a big thing about and brought cases about, particularly Epic and but also that 30%, we argue, has been passed on to consumers so that they are owed damages. There's been a similar case against Apple on a very similar basis in the UK, and that was the first ever collective claim to win in the UK courts. So that was really huge for the regime. And my case is different, but along similar lines. But obviously, the way Google runs is slightly different to Apple, who are quite happy to say we are a closed system because of security, privacy, or all sorts of other reasons. Whereas Google Android is technically open, but in practice quite hard to open up to other people.
I mean, Google is going to be very happy about this case since they've been fined 4.1 billion by the commission like last week.
Yeah.
So,
Yeah,
yes.
they're fighting on a lot of fronts at the moment.
Yeah, I mean, they've been using their powers, their global powers to amass a huge richness. And then, of course, now the global powers are kind of amending to that issue, let's say. It's not that Google, there's something that I think is a big issue when we talk about this kind of claims, is like you don't necessarily want to disable all the services that these big companies provide. Of course, there are great things for consumers. I think we all use Google search at least 15 times per hour. I think I read this kind of statistic. It was crazy that the average, I think in Europe, was 15 times per hour. But at the same time, there are also things that need to be fixed, and it's fair to bring them back on the right.
I mean, you can have the most fantastic service provided by anybody, but you can also have fair access to services provided by someone else if someone else wants to use them. So, I think obviously the companies would argue people use these because they're the best, but it's hard to say how much that stacks up if there really isn't viable alternatives that you would use, particularly where there's a network effect, whatever. So yeah, but it's certainly an interesting time.
Yeah. And I think even people are becoming a bit more savvy with like using different apps and this whole idea of like using different services for different things.
Yeah.
The multi-platforming effect that Gen Zs are accused of. They have tons of apps and they use them all, which is, sometimes good, sometimes bad, depending on who you're trying to reach out to. Because then, I don't know, but so many of my friends go like, "Oh yeah, can you text me about this on Instagram, please? Because it's like better." And then they go like, "Oh, but yeah, please on Snapchat." And then like, you're like, okay, well, just pick one.
Yes, yeah. And they sort of instinctively know where you would find people.
Yeah,
Like
which one is better for
which
what?
works. Yeah.
So-
Yeah. I know. I was really shocked to find out my son was like, "Oh, you and my aunties are the only people who text me on WhatsApp." I was like, "Really? Where are you then?"
Yeah, I think like when you have like school groups in some countries,
Mm,
like WhatsApp is very much used for school purposes, but yeah, other apps are preferred by younger people. And then
yeah.
I think you can see which age group the person is from by the type of apps
Yeah.
they use, and you're there
Yeah.
like, okay, well, you're a bit more on this side than on that
Yeah.
side.
Interesting.
Also, I wanted to maybe fix this concept with our listeners because I think
Mm,
this is a bit more difficult to understand if you're not from the legal
mm.
background or you're not interested in law. The kind of opt-in and opt-out regime, because it's a peculiarity of any type of regime that allows for class actions or
Yeah.
collective representation claims. So in some parts of Europe, you can find opt-in regimes, like in Germany, where people have to sign up for accessing
Mm,
a claim. So it's when you receive a message from your consumer organization that says, if you are affected by this issue, sign up here or like
mm.
register here. And then there are some other areas of the world where something like an opt-out regime is in place, and the UK in some cases has this effect where basically all the users or all the people that are corresponding to a category are immediately considered within
Yeah.
the claim unless they want to opt out. So unless they
Yeah.
say like I'm not interested in receiving this or in receiving this kind of
Yeah. So it's a
position.
weird wording because it's called opt out, which makes it sound like you're out of it, but actually you're in it. So it's
You're
default.
in it by default, yeah.
Yeah, you're in it by default. So yeah, they work particularly well for claims where perhaps not a huge amount of money would have been lost,
Yeah.
but the effect, say, across the whole economy would be huge. But it wouldn't be worth the effort of going, of taking something to court as an individual. So I think they suit the digital market. They suit things like where people have sliced off too much commission or not communicated that, or things where there's complicated supply chains where you're not quite sure who's paid what and how much of that has gone to the price that you've paid. Um, I mean, I think some opt-in cases also may have relatively low amounts, but you also, as particularly in the UK, and I can't speak for other regimes, you'd sort of need to have a very shared harm. So,
Mm.
for example, on Dieselgate, that's operated reasonably well as an opt-in because you know that you've got. I mean, yeah, in theory, you've got your VW car or any of those other makes. If you've got a type of engine that you've been affected, and then you can kind of just opt in and say, "I am the owner." With opt out, so for the around 20 million consumers that I'm representing in my case, um, there is lots of notification. So you let people know, you publicize the cases. So if somebody doesn't want to be in it, they can very simply apply to opt out. So, but otherwise, you sit back and you wait until the case hopefully is won and that the money is distributed. Um, so it's a mechanism that, yeah, where cases have quite it's not easy to get an opt-out case certified. You need to um, reach quite a lot of different thresholds in terms of the practicality of it, being able to actually have a good methodology to show how you would work out the quantum of damages. And also in the UK, a lot really hot on whether you will be able to reach this class. So there needs to be a practicable way of identifying them, informing them, and more emphasis has been put on then sort of activating people because eventually you would have to go and make that claim, and what level of evidence you might need for it. But I think with the App Store case in my case and the Apple one, there's a type of tech claim where the customer base is well known and if you have an Android phone, right? And and sort of a few clicks to look at your billing history on the App Store. So it's a much easier barrier to get through, whereas some other cases in the UK have been about overcharges by train companies, because we have the joy of privatized train companies and the confusing like plethora of ticket types and different boundaries. And a case was settled where damages were distributed to people, but it was like you had to say, did you travel on this route between 2015 and 2018, and if you had this type of ticket, then you can get this. I mean, that's you've sort of switched off, probably not wondering whether you did travel or not and what ticket you had. So for those, they might bring down the evidence threshold. I think for that case you could claim up to about £60 without any evidence. So they're trying to make it easy for people, but yeah, you need to have a viable way of distributing to the class. Otherwise, you're not, the regime is there to get money back to people. And so you need to do that to a reasonable level.
I find that fascinating how you describe the kind of like, okay, for opt-out, like if you, provided that you have met the threshold, you kind of sit back and wait until the case is won and stuff. Because I think probably something that individual claimants would kind of notify is that obviously legal expenses are very kind of considerable, especially I'm thinking in the UK, because of course in other countries you have caps, for example, but the UK is famous for being rather expensive. I would say like not the most expensive, but decently expensive. Yeah. So I would ask you like to what extent do you think that level of expenditure on your side, probably on your organization side, is justified when the amount that's going to be given back to the consumers is very low, even if it's a widespread number of consumers? And the risk is that they don't, probably, like, people, as you said, have a lot of things to care about. So they probably won't care until probably they receive, say, £60 or even more. But like still, it's something that not everyone can get involved in if they're not passionate about having paid in the App Store or something.
Yeah, it's a really good question. So I think there's different elements to it. I mean, when I say really small amounts, I suppose if you look at damages that you're claiming for since 2015, for some people, they could well be quite a lot. And if you do it on the basis of what someone's actually spent, which, how you actually define what somebody is due, whether it's an aggregate average or whether it's like individual, it could be actually quite a lot if you're a gamer or you're subscribing. So it could be a significant amount. It just still wouldn't be worth, it still wouldn't really have the means to bring an individual case. And I think when I say sit back, it's more, you don't have to take any risk as a consumer. You're not liable for anything. So there's that level of, and I suppose I don't know whether that's a positive or negative, like whether justice should work without people having to be activated for, like, we launched the case in 2022, whether people need to be following it for 4 years to be due justice, or whether it's fair enough that you can, there are other means, people who are doing that on your behalf. But in terms of, I suppose, in terms of your point of the balance between, I suppose what you're asking is what a person might get at the end versus a lot of the costs of this. It's a good point. I think if a company, back to the basics, if a company's done something wrong and overcharged you, they should give it back regardless of the cost. If you can do that in a way that doesn't give any risk to consumers, I think that's a good thing. I also feel there's lots of other elements about justice being shown to be done, which is back to my point, I think that I said before, of what can we do about this? This is a really tangible way to say you can hold people to account. It might not be the way that everybody would want it to be done, but public enforcement is not funded to be able to do this. So this is a way through private enforcement, and people may balk at the cost and not really be big fans of litigation funders, but this is a way that companies can be held to account and can't just do what they want without consequences. But that's more of a kind of principled point. I think the other thing I would say is the UK is not a huge like claimant culture. So we've also got a bit of a hurdle in, letting people know that this is not a dodgy, no win, no fee kind of claims management, because that sector doesn't have the best reputation and there is a lot of mistrust, but that this is a new way of holding companies to account, feeding back that money back to consumers. And I think that will take a while to build, because I think that is quite hard. To sort of have people alive to those things. So that's part of what lots of different class reps in the regime are trying to do as well, sort of create more trust. So lots of people are doing a lot of work to be on, trusted consumer programs, or to be communicating this in a way that people can sort of engage with. I think the other thing to say about the benefit, so there's benefit, I suppose, benefits to individual consumers, benefits to companies being held to account and being more careful about what they do next time, and then benefits to the economy generally, that money is sort of staying within the economy, and then so far with the settlements that we've had, there's been a portion ring fenced if it's not claimed by consumers, that will go to a charity called the Access to Justice Foundation. So these would be millions of pounds that they'd get, which then the Access to Justice Foundation funds legal services all across the country. So it would be frontline advice. So you're sort of also creating access and resources for access to other types of legal rights and advice. But it's sort of it's all still so new, and there's so few examples there's been a few settlements, but some of them are so sort of esoteric almost, and they wouldn't really read across, that you can't read much into them. But I think coming up, there's a larger settlement which is really focused on distribution, and obviously with the Apple case, hoping that would sort of set some kind of standard for how you might do this. But I think it's a fair point to say, what do consumers get out of this? Because at the moment it's so new and we don't quite know. We can't be sure of what the take up will be, or what would be a good level of take up versus what's just a practical level.
I actually love that, because if you ask the average person, like, are you not freaked out by the actual fact that specific companies are asking you much more data than they need? By, like, obviously, because if I am asking for a map service, you do not need to see everywhere I've been online for the past 5 years, possibly. Like, there is no need. And people are like, well, that makes sense. But the moment you are a consumer organization that actually wants to do something good for the balance of powers, the answer that you get 99% of times is, where's the Ponzi scheme and where's the scam?
Yeah.
And you're then like, I mean, sure. I mean, certainly there are cases where, legal claims or like legal loopholes are used by people that know more about it to scam people, or to get a bit more out of it than in other cases. But still, there are companies that are literally stealing value data, like in money kind of measurement. And the fact that you do not ask yourself, is that fair, but wonder whether this is a scam. I think it's all a PR kind of
Yeah, it's a really good point.
issue. Like it's how people think, like it's not an issue if a big company is getting all of my data without even
Yeah.
needing to. But definitely if a consumer organization is going to go for a claim on my behalf, that's a scam. There must be something
Mm,
behind it. It's
mm.
I think it's absolutely hilarious how people think, and
Yeah, that is quite interesting. And even things like when I started talking about my case, it's not really, I don't know how, I need, because it's hard to tell, because I've sort of been in this world for so long and I was aware of the 30% commission for so many years before this case. But talking to people I know or friends or whatever, they're like, well, I didn't even know that the App Store
yeah.
charged commission. So I think there's also a bigger point about the transparency that bringing these cases can bring to say, to say they charge this, and then sometimes people go, well, that's okay, isn't it? Like, is that good or bad? Is that high or low? And then you can give them a comparison of what, say, a payment service person, okay, that seems a bit high. And then, but can't can't big companies just charge what they want? And then you get into this is when people, don't want to talk to me anymore in the pub, but then you can get into like, no, they can't charge that much. They can at at the beginning, but you should then move to an open market where it's competitive. But under competition law, no, you can't just be huge and charge what you want, because that's the law, sort of thing. So there's a sort of education piece there, which people may not
Yeah.
want. They may just want the money back. But I think there is something about that's why I think these claims, which can give back monetary value into people's pockets, kind of grab the imagination a bit more than having a conversation about regulation, or it's a sort of bit more of a tangible way to get people's attention.
I'm wondering on the point of getting people's attention, how do you feel that goes in terms of outreach? What kind of means you're using? Are you using, for example,
Mm.
social media? How is the press helping you in this? Because I feel like whenever I watch TV, there isn't such a hype about these type of cases. And anyways, it's once maybe when the case gets discussed, but I wouldn't say they remind you of these important
Yeah,
factors, do they?
I mean, it's something about timing, and I think people working in this area have there's a range of views. There's something about, do you sort of prime people, keep them in touch with what's happening with these cases, or is there not really, or is it better to wait, until you get to the trial, or until you get to the judgment, or until you get to distribution? So there's something about at what point do you go for the engagement? And I think that always depends on what you want to get out of it. So, if it's for actual activating someone for distribution and getting someone to do something to get that money back, you'd have, you'd be using a different approach. If you're wanting, I think what reps have tended to do is go in for raising more awareness around trials, which has been I think been reasonably successful, and getting people registered. So each claim will have its own website where you can stay updated. But I find the challenge that there's not always, for the legal press, there's a lot of interest in the updates and the sort of consumer, policy press. But for an individual, what are you saying? Like, this case is going through, and you may get, and if we win, there'll be damages returned to you, but you can't really say when. And so it's sort of, I think it's a really tricky one. Like, at what stage and if you just keep a drip of what's happening, that may impact some people, but I don't know. It may be more go for the big bang around the newsworthy moments, like winning a case and things like that. So I think all of these things are to be discovered. But I wondered what from your experience in other countries, or what you think about that as well.
I think, for example, the thing that you have an opt-out regime is very helpful because, I mean, after all, people are kind of, I mean, having to be looped in the sense that at
Mm.
least I think the defendant sees that number at the end as being a roughly applicable number of
Mm.
the people that they have to give the money back to,
Yeah, yeah, yeah,
possibly,
yeah,
The issue with opting systems is that technically people, I think, are much more like consumers that sign up for it or
yeah,
register for it are much more interested in the claim because they had to do the actual work before.
yeah, yeah,
So
yeah, yeah.
they
You've
had
got the
to
work up
to
front.
actively put, yeah, exactly.
Yeah.
But at the same time, um, the threshold I think in Germany is like 50 consumers. Or
Mm.
so if I'm in thinking in terms of a Google, if in front of me I see like a big claim, but technically 75 people, and the lists are public, so you know
Mm.
how many people have signed up. Technically, 75 people have signed up for it. I'm not sure whether I would see it as a huge kind of threat. Of
Yeah,
course, for holding people like for holding companies accountable, it's still not nice if the TV
yeah,
then
yeah,
announces that's been happening
yeah.
and they've lost the case. And of course, it's not just Google. I mean, I've just took a random example there.
Mm.
But at the same time, like if I'm trying to maybe put some pressure and
Mm.
getting them to change a practice, I think in opting regimes, it's much easier and much more effective to use other types of class methodology or class claims.
Mm.
So you see a lot of injunction cases. Because if I then tell you, okay, you don't have to pay back 52 people, but you have
Yeah, you have to
to
stop.
stop doing it, otherwise I shut you down. Of course, that's a
Mm.
bit more of a threat. Um, but then, with the opt out, the issue is that people just do not get interested in the claim because what's the point of interest in them so early on when technically the results will come at the end and
Yeah,
they will be touched by the results, not the whole
yeah,
process.
yeah. And again, I think we're all learning this as we go along. I mean, there's organization called Consumer Voice, which is sort of trying to say that she's done some research on if you're an individual who uses Amazon, who has an Apple phone, who has Microsoft, or who does gaming, the cases that are going through, if successful, would give you, and then there's a much bigger figure because
Yeah.
all of these cases are covering huge amounts of population. So there's that. I think that's a really good way to think of it, not in, and possibly not in the way that a legal team running a case would, or a funder was, where it's just that group of people you want to connect. It's like as UK citizens and consumers use heavily like locked into this world of big companies, there are cases going through which could result in you getting hundreds of pounds at the end, or your family, if you, and I think that's a consumer way of thinking about it. And then you might have more traction to keep that. And this is what I meant a bit for like the redress culture and the just to know that, yeah, it's not bitty. This is a movement which could actually benefit you coming through.
I'm wondering if, I mean, obviously, I understand the legal side of it, and I'm
Mm.
obviously interested in the legal side because I come from a legal background, so I see why that's super interesting and why I want to know more about it.
Mm.
But I'm wondering if in this kind of actions, there should be some level of, I'm not just saying PR, but like proper marketing, which obviously you would have the issue of like how ethical is it? Um, but I'm wondering if, I remember, I think it was Taylor Swift a couple of years ago, she released a new album and people were waiting for it for like a solid 18 months. And like but that's also like, like these stars are really good at PR it. And
You
so
think we should
like
have like Easter eggs everywhere?
yeah, no, I'm just
Yeah,
wondering if you need to like, have like run an influencer campaign for doing this and like this kind of stuff, which is like
yeah.
probably also sounds very young as a way of acting.
No, I think people have
But
been. I think it's all open, and I think more and more ideas are coming through from what previously I think that's what's super interesting about it in the UK, that these are very different. Collective consumer claims opt out on this scale are very, very new to everybody working on them. And the class reps, because all the ones in the UK are headed by an individual, come with different campaigners who know how to reach people. You have some people who work in digital marketing or have PR backgrounds because they've worked for huge consumer associations. So I think it is all up. I think it is all of these things are being thought about. Alex Neil and Rachel Kent, who were class reps on the Apple case and the case against Sony, both use social media specialists, and really explained some of these. There's a lot of legal jargon, isn't there? Like really explaining, what is a competition appeal tribunal in quite a fun and accessible way, and just kind of kept up that, bringing it to them as people who were leading these cases and why, and so I think that's one approach. I'm exploring with with some sort of communications and PR people what would work best for our case. So it is interesting, and it's quite. I think that's what sets it apart from, I suppose, like opt-in cases where you've got your list of people who've joined, or where I know consumer groups run a lot of the opt-in cases on behalf of people, and they have that direct link because you might be a member of that consumer group, so you've got that as something that you're hearing about. But I think it's quite exciting how you might raise awareness, and I know from the Sony case it was using finding out where the gamers were. So there's no point really going, you might not be getting that from a certain newspaper, but if you're on the Reddit streams or things like that, that's where you would find the people. So it's really, I think it would be very tailored for different groups and different claims.
Yeah, it's exciting because it's a type of legal work that kind of extends to a lot of things, extends to really understanding where the centers of societies are right now, which is probably less. I mean, as much as other legal work is very important, but I'm thinking of an M&A lawyer. I don't think they actually ask themselves where are people actually getting info from now. Hopefully.
And things like, well, what would it, is there a threshold that would get someone willing to click and sign up and take the action to activate the damages? What is that? And does it vary between people, or is there actually, can we roughly say, look, if it's under X amount, then it's probably not going to get a bite, So it's sort of all of these questions which we are all learning. But I think what's really good with the number of consumer advocates who are involved as class reps is that this is very much their bread and butter of you can't just put something on your website and hope people will come. It's a much more informed by behavior and needs and income and where people are and timing. So it's actually, but you're right, it's access to justice. It's a strand of access to justice. There's no point having all these laws on the statute books and cases being brought if
nobody knows about it.
Nobody knows about it, yeah. And then you also, it's about legitimizing the regime and public support for it, because there are people who don't want these claims to be brought and are working quite hard to be dismissive of it and point out all the problems. But so I think you do need to keep a positive engagement with the people who ultimately benefit.
Yeah, I always make the example of the I have a right to a lawyer, because I think not many of us have actually been brought to jail or arrested by a police person. I hope so. I mean, I don't know our listeners, not all of them, but I'm sure. But I think all of us still know that probably if someone comes to you and wants to arrest you or something, the best phrase to say is I have a right to a lawyer. And even if you probably haven't been told by the policeman that needs to inform you, you still know. Probably because there are loads of TV shows of policemen telling it to the arrested person. And I always wonder, what if there were a Netflix series on the topic of class actions?
Law and jokes,
Imagine.
That would be so cool.
To any Netflix producer, this is an official call. Um,
Love that. Standing in a shop shouting, I have a right to a consumer lawyer.
right. Hey, I opted out. Um, one of the last questions I really wanted to ask you was, as a consumer representative, do you feel, and that's like, I think it's a bit of a harsh one, but I'm aware of it as I say it.
Yeah, yeah.
Um, do you feel like a settlement is a victory or is it a concession? How do you feel towards the idea of settling a claim?
I think a well-designed settlement it can benefit consumers. It can really get things done much more quickly. So back to what we were just saying of getting the money in people's pockets. If you can do that without, a long trial, a long wait for a judgment, very likely appeal, you're losing, that's at least a year, but more likely 18 months before any distribution can start. So that's that's helpful. I think it's viewed as a real it's encouraged in the UK regime.
Mm.
And I don't know if that's the case in other regimes. It is encouraged because of reducing the litigation risk, um, and reducing sort of the times and costs in court. So it's actively, and it's supervised as well. So I think if people have an idea of a settlement that kind of behind closed doors and, on the doorstep of the courtroom, it's absolutely not the case for the UK cap regime. It's you can present a settlement. It needs to be approved at a separate hearing and get an order, and they can be, they can be they don't have to get approved, so you can may have to go back and change them, which is, I think, which just put you in the position of being able to take that as a viable approach with quite a bit of protection around it, because the cat would reject it, because they are also their role. The cat would reject it if it wasn't seen to be in the interest of the class.
Mm.
So they are ultimately there to help protect the class interests. So I don't, yeah, I don't want to say it depends, but it's a viable route to getting damages. It's obviously, you mentioned injunctions before. Most of, if not all, no, I think there's one case going through which is seeking injunctive relief and damages, but most of these cases are damages. So it's more about the settlement you can get and get back to consumers, whereas I suppose for injunctive it could be different.
Yeah, yeah, I think that's a fair point to bring about. It's like, because if you go for a damage claim, of course, like the expectation is that you still
Mm.
then split it towards
But some of the
amongst
damages
consumers.
claims follow on. So they've been there's been some public regulation or findings that they do need to change, like there is for the app stores, that they do need to allow other ones. So they've actually already changed some of their practice,
Mm.
but there's still 10 plus years of overcharging. So it's not. So
Yeah,
it's a slight, yeah, it's this kind of like hybrid sometimes of what change is happening.
that's a really good point. Like settlements, I think the general view on settlement is that I like it's a legal way to use money to kind of shut people up, basically, to avoid that they go and say more about the issues
Mm.
that they've encountered. Whilst I think probably a bit more information about what settlements are and how they work would
Yeah,
be helpful for the general public's vision of, no, we weren't trying to just get the money and put them in our
yeah,
pockets. It's
I think that's a good point. And yeah, and it is a huge, I think it's a huge responsibility to get it right, because you know, you're sort of making a decision on, perhaps we could get more if we take it to court, but then it would be years, and but we'd also get nothing. We could also equally get nothing. So you're sort of and I think they're really big decisions, which is why the supervision of the cat is really, really important. And they would look at things like if in the settlement you'd signed, you'd agreed that no other action would be brought against the company. Is that fair if you've got an opt-out class? Because does that mean then you've put, 500,000 people into your class and then they don't have rights to bring a case against someone? So all of these things need to be really, really carefully supervised with opt-out in a way that they wouldn't if it was if it was a dispute between two commercial companies.
Two commercial companies, yeah.
Which is why it's so carefully structured in the CAT. And I would imagine it must be in other regimes if it's a consumer class involved.
Yeah,
But
it's just that the
I
term
think
is always settlement. So like people think of the settlement and not probably of a rigid, like, I don't know, coordinated redistribution coordinated
yeah,
by the court or something like a bit more descriptive of the whole process rather
yeah,
than just
yeah.
settlement,
Like you say, for people who don't, where the law's not top of their mind every day, certain things have, you attach sort of meaning to certain terms, and then settlement could mean all sorts of different things to different people. Whereas some people might see it as very positive, it's like, well, that's actually a very sensible way to go forward. Others may see that as you're not bringing people, you're not doing the job of bringing people to justice. But yeah, so again, it does raise a lot of different questions. And I think in the UK we don't. That's all new as well. So how people respond or how people feel about it, I don't know. We don't know yet.
Interesting.
Hopefully, if they get the
I'm
money.
I'll be
That would be
waiting for an update on this when the case is how is what's the timeline of the case? Can you share that a bit with our
Yeah,
listeners?
yeah. Well, we've got pre-trial review, which is the 31st of July, so the end of this month, and
Mhm.
then the case starts 5th of October. So
Okay.
that's really exciting. So it's
With a
all
new prime minister,
new
hopefully.
Prime Minister. Yeah, all change. But yeah, so we should be finished by Christmas and then wait for the result.
It would be interesting if because in some countries at Christmas time you get like extra money in your um wage to like say, okay, well, in your payslip,
Your
you've been
Christmas
working
bonus.
hard. This is
Yeah.
your Christmas money. I'm wondering if these people will receive a little bit more and be like, okay, well, remember that thing you did like 3 years ago?
Yeah.
It worked. Super nice.
Yeah, yeah,
Um,
but it's great to see it come to fruition. This was started, we filed 2022, so it's a long time.
yeah,
It's
yeah,
a long time when you
it
don't
really
work,
is.
when you don't like aren't closely associated with sort of legal cases. As an advocate and a consumer campaigner, you kind of used to things moving super quick, and then this is a
Oh yeah,
different
I
timescale.
can.
Yeah.
Yeah, I can actually relate. I think
Mm.
people don't realize how slow things are, and
Mm.
it's crazy to think that technology, meanwhile, is evolving the
Exactly,
quickest pace possible.
exactly.
So
Yeah,
they're like, well,
yeah.
actually, like this is like seven version of app stores
I
before.
know.
It's
Yeah,
crazy.
yeah.
Yeah. So I'm thinking like looking forward to what will happen after the claim is hopefully won. What kind of issue are you wanting to focus on afterwards? So what area of the digital space would you want to work on so that it doesn't impair consumers but empower them?
Okay, I think obviously data is a huge one and just getting more and more important as more data is collected and used for sort of training AI. And I know that is there's plenty of people who are also interested in working on that, including like at Spirit Legal. The other thing I think is back to my point earlier about thinking about the consumer as a whole or the consumer market for digital as a whole. So this isn't about a specific area. It's more to say I would love to see a lot of more strategic joining up of cases that are bought because it's a really powerful tool. At the moment, cases are being pursued on, legal merit and all of those things. But is there a much smarter way to do this if it's across the country or also with groups in Europe to bring cases based on a particular type of practice, or on a particular product or service or particular infringement, so that you're taking a much more strategic approach and you're avoiding like overlaps with different firms and all the expense of that. So if you're thinking, so I would like to see, how can we think together as a collective about where you might be targeting particular companies, which might be like the kind of Black you gateway companies or leading this behavior, and how you might do that in a more systematic and hopefully more efficient way. I haven't quite worked out how that would work, but that would kind of be an ambition of mine, to see it work much more, to make some sort of strategic systemic market change.
Yeah, that's a very difficult thing to coordinate. Why am I not surprised that you're
We'll
going
have
for
a
that?
go. We'll do the Netflix series and then we can do this.
I think the Netflix series could be useful, actually. I mean, I'm just
Yeah,
saying
yeah,
for coordination purposes. No, but that's actually, I mean, in the EU, when you have claims that are very similar, you
yeah.
have to make sure that they really target kind of like different areas, because otherwise there's this problem of like, if you're doing a cross-border action, there's this problem of like if two claims overlap, then probably they will be assigned to either or country. So yeah, it's harsh to define the scope, the legal basis, because obviously different countries have different laws. So like in the UK, you're focusing a bit more on competition. In other countries, you can use other. So I know for a fact that Germany is using a lot of data protection law. And obviously that means that probably the companies are the same. I mean, they're always the
Yeah,
same ones. But the way you have to target it is different depending on the law, depending on the procedures,
yeah,
depending on the regimes, depending on the enforceable, and on that it's a problem. Civil procedure, you can
yeah,
have a law and then you do not have an enforcement mechanism. So
yeah,
nice, we have right to damages. Which damages? No clue.
yeah.
So yeah, it's super interesting, and I'm sure I'm looking forward to seeing you embracing this new idea.
I think it's something like that, I really like the sort of strategic litigation that the Digital Freedom Fund and Luminate and people that met at the conference with you were doing. And I think it's that's not such a big tradition in the UK. It's trying to see where you could you use that for consumers. And maybe you can't, but I think it would be really interesting to see if you could bring it all together a bit more.
Yeah, like the UK working with other countries in Europe? Seriously?
Or even just maybe just even between UK law firms, maybe that would be difficult enough.
Okay, fair enough. Well, and on that Brexiteering note, I will thank Liz Coll for joining us. Oh, well, me on the Legal4Tech, the
Thank you,
podcast.
everybody. Yeah, thank you. It's been really great to chat, as always.
This episode was brought to you in partnership with DG Beetle. DG Beetle helps privacy professionals to stay up to date with the most important European documents in the AI, data and digital space every day. Curious to know more? Check out the link in our show notes.